Every generation is told the same lie. Your vote is your voice. But if judges can decide which voices count, then your vote isn't a voice, it's a permission slip. The right to vote should be absolute. Yet today, it's a privilege constantly balanced against state interests. And the weapon that made it that way is something most Americans have never heard of: the Anderson-Burdick balancing test. This is a story of how two obscure court cases turned the sacred act of choosing your government into another bureaucratic filter, a scale where liberty loses by design. This is Constitutional Outlaw. Episode 5, the Anderson-Burdick balancing test, voting rights on a sliding scale. A right turned into a reasoning exercise. The Constitution says plainly, the right of citizens to vote shall not be denied or abridged, not unless it's inconvenient, not unless the state has paperwork problems, not unless a judge thinks the law's burden is reasonable. Yet, that's exactly what happens now. In 1983, the Supreme Court decided Anderson v. Celebrez. It was about ballot access, an independent candidate barred by early filing deadlines. The court said, yes, voters have rights, but those rights must be balanced against the state's interest in orderly elections. 7 years later, Burdick v. Takshi cemented it. The court upheld Hawaii's ban on write-in votes, declaring that not every restriction needs strict scrutiny, only a sliding scale of reasonableness. Translation: your most fundamental right was put on a mathematical chart, weighed, measured, and discounted. The disease of balancing. Think about how insane that is. The same government that counts the votes now gets to decide how hard it can make voting before it violates the Constitution. That's like letting the fox write the rules for the henhouse. They call it administrative efficiency. I call it disenfranchisement wrapped in bureaucracy. Judges pretend to be neutral referees. But every balance tilts toward control. When they side with the state, they say, the burden isn't severe. When they side with the citizen, they call it an exception. Freedom is never the default. Compliance is. That's the danger of all balancing tests. They turn absolute protections into variable privileges. How it spread, the virus of reasonableness. Once the courts tasted this logic, they applied it everywhere. Voting rights became the model for every other right. If they can weigh your ballot against the state's interest, they can weigh your gun, your privacy, your speech, your faith. Every constitutional guarantee now lives on a sliding scale. Anderson-Burdick wasn't just about elections. It was a judicial blueprint for obedience. Every law limiting liberty now survives under the same excuse. The burden is minimal. Minimal to whom? The judge? The bureaucrat? The citizen who can't afford a lawyer? When liberty is filtered through bureaucracy, liberty dies by paperwork. The patriots view what the founders would say. Imagine telling Samuel Adams that you needed to balance the right to vote. He'd probably balance your teeth on the cobblestones. The founders didn't draft the Constitution to be flexible. They wrote it to be final. They believed power corrupts, and balancing power against rights guarantees corruption. They gave us elections as a check on government, not a courtesy from it. To balance the right to vote is to admit that government, not the people, is sovereign. The American Revolution wasn't fought to make tyranny efficient. It was fought to make it impossible. Modern consequences. Look around today. States purge voter rolls, redraw districts, close polling stations, and bury registration in digital labyrinths. Every time, courts ask, is the burden severe? As if losing your vote needs to be severe before it's unconstitutional. They've normalized disenfranchisement through vocabulary: reasonable burden, legitimate interest, administrative necessity. Each phrase means the same thing. Sit down and shut up, citizen. The right to vote was the line that separated rulers from the ruled. Now it's a checkbox of convenience for the very people it was meant to restrain. The bigger lesson: all rights on trial. Anderson-Burdick is just the mask. Behind it is the same disease infecting every liberty in America. The belief that rights can be balanced against government interest. That's why you need permits to protest, background checks to defend yourself, and disclosure laws to speak politically. Each one justified by a balancing test. You see the pattern? It's all the same logic. The court's favorite equation: government interest plus reasonableness equals your freedom in pieces. The call to responsibility. Here's the part no one wants to hear. This isn't just their fault. It's ours. Because we stopped studying the Constitution and started trusting the interpreters, we treat every ruling as gospel. We repeat their buzzwords like trained parrots: compelling interest, rational basis, minimal burden. But those words aren't law. They're legal camouflage. If you don't know your rights, you don't have any, and the people balancing them sure as hell won't remind you. Knowing your rights isn't about trivia. It's about survival. Because ignorance is the only tool government needs to rule absolutely. The movement. That's why this channel exists. To pull the curtain back, to turn citizens into sentinels. We aren't subjects to judicial reasonableness. We are heirs to revolution. Voting is not a transaction between you and the state. It's a declaration of ownership. You're a reminder that government answers to you. They've turned that declaration into a regulated privilege. Now we turn it back. Read the Constitution. Study the cases. Expose the fraud. Teach others. Because tyranny doesn't start with guns in the street. It starts with ink on paper and citizens who stop reading it. Closing verdict. When judges weigh freedom, freedom always loses. When they balance your rights against their interests, you're already unfree. The right to vote is not a variable. It's the heartbeat of self-government. If you let them grade it, you've already surrendered it. If you don't know your rights, you don't have any. And if you don't defend them, you don't deserve them. This is Constitutional Outlaw. The people's courtroom against overreach. Because justice doesn't plea bargain, and neither should you.